thought I'd go over the Code of Federal Regulations for this Title 45. And specifically, I want to go over, I want to say it's 303, parts 303, so that you can see it. I'm not going to go over this whole thing, that's a whole lot to read. You can actually download this to your computer. You can see it on your cell phone or whatever. Just type this in there. Title 45, Code of Federal Regulations. And you know, that's what it's titled, Public Welfare. It goes through from the very top to all the way to the bottom of how the child support program goes. All of it. I'm not gonna cover the whole damn thing. I'm gonna scroll down to the part that I want to talk about specifically. Is what a lot of y'all have experience on. But the purpose for me making this video is so you can understand the process of what they're doing. And I want to show y'all where, you know, a lot of us we're not aware of that this is not a law, okay? They have procedures that they have to follow. And you have an obligation, you have a how can I say? You have a choice on whether or not you want to participate in it or not. They need your compliance in order to do so. I'm gonna read it. I'm gonna start this right here, but I'm gonna start something off real quick because in one of these I was reading earlier, but they was talking about how they have to have your social security number in order to do that. Not your social security number, but your estate's social security number, the social security number that's attached to your estate, because no man or woman has a social security number, okay? So let's get that out of our head. Let's get it out of our language. We don't have social security numbers. Your estate has a social security number attached to it. It has a social security account. It's an account, y'all. And it can be monetized when you use it. That's why you need it on every application when you apply for something. You need that social security number to do it with your estate information. When I say your estate information, that's your all caps name information. That's the name of your estate. You need that estate information along with that social security number so they can use that social security number account number. That's what it is. And I'm going to show that to you in order for them to move forward. Now, I don't want to go into the Federal Reserve Act 16 because it'll tell you that the federal, applications are to be, what they do is any application that you fill out, any entity that you fill them out, you turn them into, they actually are, by them being financial institutions, they can turn those into the Federal Reserve, one of the 12 Federal Reserve banks, in exchange for Federal Reserve notes. So that's why you've never borrowed any damn thing. So when they pretend like the state have loaned you something to take care of your kid and they talking about you pay it back, that's the fraud behind. That's another angle of fraud. If you look at the Federal Reserve Act, Section 16, Part 1 and 2. It's an illusion. You never borrowed anything and they never loaned you anything. Banks can't loan any damn thing. They only borrow. Okay? And that can be confirmed also in 12 USC 1431. 12 USC 1431. But we're not gonna, that's not the subject for today. That's just a little side note. Now I'm gonna start off reading this part right here. Here we go with Social Security Administration right here. As y'all see, this is Social Security. This is the Social Security Act. You can type in Social Security Act, Section 1137, and you'll find this, okay? It says, in order to meet the requirements of this section, a state must have in effect an income and eligibility verification system which meets the requirements of subsection D and under which a state shall require, I mean they have to require it. You know what I'm saying? It didn't say you must give it. It said the state shall require it. They have to require it as a condition of eligibility for benefits. So if they don't obtain it from you, somebody won't be eligible for the benefits. Okay, as a condition of eligibility for benefits under any program listed in subsection B. I'm not going to look for subsection B right now. I'm going to stay focused. That each applicant for or recipient of benefits under that program furnished to the state his Social Security account number. As I said, the Social Security number is an account number. Okay, for his Social Security account number and the state shall utilize such account numbers in the administration of that program so as to enable the association of the records pertaining to the applicant or recipient with his social security number. So now you see, they have to have this type of stuff in order to for them to even be qualified to be eligible for any type of benefits or any program. Okay, so go back to where we was. Okay, and matter of fact, I'm gonna read this too since I accidentally clicked on it. This is one of my windows that were open. 45 CFR subsections 205.52, furnishing of the social security numbers. A state plan under Title 1 for A 10, 14, or 106. That's what C, in case y'all didn't know that, of the Social Security Act must provide that a condition of eligibility, each applicant for or recipient of aid will be required to furnish to the state or local agency a Social Security account number. There it is again, proof that the Social Security number is an account number. Okay, herein referred to as a Social Security number or numbers if more than one has been issued. And if he cannot furnish a Social Security number, either because the Social Security number has not been issued or is not known, to apply for such Social Security number through procedures adopted by the state or local agency with Social Security Administration. If such procedures are not in effect, the applicant or recipient shall apply directly for such number, submit verification of such application, and provide the number upon its receipt. Okay, do I need to read this whole thing? I don't need to read this whole thing. I just want to show y'all that they have to have the Social Security number in order for you to, anyone to be trying to be eligible for any one of these plans right here. Okay, now we're gonna move forward. Back to right here. This is the procedure right here. Establishing support obligations. I wish I could find that PDF that I had before in my emails. It's probably in my emails, but I can't pause I can't pause a screen recording and look for it. So I got to keep it going. Okay. Establishment of support obligations for all cases referred to the Title 4D agency or applying under 302.33 of this chapter. The 4D agency must, when necessary, establish paternity pursuant to the standards of 303.5. That's A. 2 or B. Use appropriate state statutes, procedures, and legal processes in establishing and modifying support obligations, and in accordance with 302.56 of this chapter, which must include, at a minimum, taking reasonable steps to develop a sufficient factual basis for the support obligation. Okay, they got to do that first. They got to do that supposedly through such means of investigations, case conferencing, interviews with both parties, appear and disclose procedures, parent questionnaires, testimony, and electronic data sources. See, this is what they do all in the process when they going through the court cases. Okay, when they have all that stuff going on. Let's see, gathering information regarding the earnings and income of the non-custodial parent, and when you noted that it say both parents, they say the non-custodial parent. Say when earnings and income information is unavailable or insufficient in a case, gathering available information about the specific circumstances of the non-custodial parent, including such factors as those listed under 302.56 C13. I should be looking at that of this chapter. Let's see what that says. I don't want to lose my spot. I'll do that later. Basing the support obligation or recommended support obligations. Keep in mind right here, y'all. They gotta have that to move forward too. Okay, you don't have to give them that. That's your private information. That's for you. You have the right to be secure in your papers and your persons. Okay, that's Constitution. They can't violate that. So you don't give it to them. You file an objection in there. You don't want to. You let them know you have the right to privacy. That's what you gonna exercise there. You don't need to give them any of that because it's your private business. It ain't none of their damn business how much money you make. Okay. Now, basing the support obligations or recommended support obligations amount on the earnings and the income of the non-custodial parent whenever available. See, they keep on saying whenever available. They said that earlier too regarding the income. Yeah, say and income is unavailable or insufficient. Okay, here we go. Keep going. If evidence of earnings and income is unavailable or insufficient, there we go again. Unavailable or insufficient to use as a measure of non-custodial parents' availability to pay or ability to pay, then the support obligations or recommended support obligations amount should be based on available information about the specific circumstance of the non-custodial parent. That's why some people say including such factors as those listed in. Let me look at this shit here. I want to look that shit up. Let me just look it up real quick. I keep seeing stuff like that. I think this is Title 42, so I say 42. C13, let me see. C13, C1. Okay. Child support guidelines. Okay, it's child support guidelines under A. Paragraph A is up here. It's a guideline for setting child support orders. Within 1 year of completion of the states. Let me make this bigger, so y'all that might have need to see this a lot better. Within 1 year of after completion of the state's next quadrennial review of its child support guidelines that commences more than 1 year after the publication of the final rule in accordance with 302.56E, has a condition of approval of its state plan. The state must establish one set of child support guidelines by law or by judicial or administrative action for setting and modifying child support orders amounts within the state that meets the requirement of this section. Notice it says laws. It says child support guidelines by law. That's guidelines that they have that are by law. It's not a law for you to be on child support. Okay, they have to go by they have to follow the guidelines and the procedures. Okay, the state must have procedures for making the guidelines available to all persons in the state. The child support guidelines established under paragraph A, which is what I just read, must at a minimum provide that the child support order is based on the non-custodial parent's earnings, income, and other evidence of ability to pay that takes into consideration all earnings. Keep in mind, it said evidence and other evidence. They don't have evidence unless you give it to them. You give them check stubs, you giving them evidence. You giving them evidence of all this here. Why the hell you giving them that? You have a right to not give evidence against your damn self. Okay, so you ain't got no business giving them that. They say they need that evidence. Say provide that takes no consideration into take into consideration all earnings and the income of the non-custodial parent, and that at the state's discretion, the non-custodial parent. the custodial parent. Sometimes they don't be studying that. Takes in consideration the basis of subsistence needs of the non-custodial parent, and that at the state's discretion, the custodial parents and children who has a limited ability to pay by incorporating a low-income adjustment, such as self-support, reserve, or some other method determined by the state. And if imputation of income is authorized, takes into consideration, authorized by who? Anyway, takes into consideration the specific circumstances of the non-custodial parent, and at the state's discretion, the custodial parent, to the extent known, including such factors as the non-custodial parent's assets, residence, employment, and earnings history, earnings history, job skills, educational attainment, literacy, age, health, criminal record, and other employment barriers, and record of seeking work, as well as local job market, availability of employers willing to hire the non-custodial parent, prevailing earnings levels in the local community, and other relevant background factors in the case. Hey, they all in your damn business. They can only get in there if you invite them, though. Keep that in mind. When the judges be asking all these damn questions, y'all answer that voluntarily. You know, you have the right to keep your damn mouth closed. That's why you're supposed to file an objection in the court case and shut it down before they even get started. And you stand on your paperwork when you get in there. Address how the parents will provide for the child's health care needs through private or public health care coverage, and or through cash medical support. Provide that incarceration may not be treated as voluntary unemployment in establishing or modifying support orders. Damn, some of y'all go to jail on purpose so y'all don't have to pay child support? Damn. That's just something I just thought about. Anyway, be based on specific, descriptive, and numerical criteria, and result in a computation of the child support obligation. They put all that in consideration on how they come up with it. Okay, I'm not gonna read all that. I'm gonna go back to where I was. Okay, but I had to kind of go across there. Y'all can put that in your Google search and read that at your leisure. You got some more sources right there to read. MROs don't like to read. They don't like to show y'all nothing. Don't give you no sources to read. Here we go. Back to this. Say 52. Yep, that's the same thing I was going to read. I kept on running into that. So this time I decided to go read it. But I read more than what they were talking about. I read more of it. Anyway, documenting a factual basis for the support, or for the support obligation, or recommended support obligations in the case record. Let's see, number 4. Let me see. Say use it. Okay, here we go. Let me go back to that. Here we go. Now let us see right here. Periodically review and adjust child support orders as appropriate in accordance with 303.8. Within 90 calendar days of locating the eligible father or non-custodial parent, alleged father or non-custodial parent, regardless of whether paternity has been established. Establish an order for support or complete services. See how they say? They say regardless of whether the paternity has been established, because they don't even care if you the damn daddy. They still gonna do it anyway. They gonna try it anyway. Say establish an order for support or complete service of process necessary to commence proceedings to establish a support order, and if necessary, paternity, or document unsuccessful attempts to serve process in accordance with the state's guidelines defining diligent efforts under 303C. I might want to look that up. I know somebody called me today that they actually couldn't get served, and I didn't know. I'm like, that could work in his favor. I don't want to say put his business out there. I ain't gonna say his name or nothing, because it just might work for him. So, and it just might work for him. Let me see. Let's see, 45. Let's see what that says. Let's read. Let's see what this says right here. I'm gonna send him this video so he know what I'm talking about. So I'm gonna Let's see. Location of non-custodial parent. Let's see. For the purpose of this section, location means obtaining information concerning the physical whereabouts of the non-custodial parent or the non-custodial parent's employers, other sources of income or assets as appropriate, which is sufficient and necessary to take the next appropriate action in a Title 4D case. For all cases referring to Title 4D program for 4D services because of an assignment of support rights or cases opened upon application for 4D services under 302.33 of this chapter, the 4D program must attempt to locate all non-custodial parents or their sources of income. Or their sources of income. So they don't find you. If they find out where you work at, they ain't got to find you. Say or their sources of income and or assets when located, when location is needed to take the necessary action. See, if they don't even find you, they can find out what's in your name. What we got, what's in your name. I did use that social security number to find out where you work at. That's how y'all get garnished. When y'all don't want to work, y'all don't want to be served. You don't want to go through the court process. They're gonna move with that social security number at their leisure. They're gonna move forward if you don't want to get served. Okay, so that's how they're gonna move. That's why I speak so strongly about that damn power of attorney. Okay, but anyway, under this standard, the 4D program must use appropriate location sources such as federal PLS. I think that's parent location system or something like that. Yeah, parent locator system services. Okay. Interstate location networks, local officials and employees administering public assistance, general assistance, medical assistance. Let's see. I was thinking something. I had a brain freeze for a minute. Supplemental Nutrition Assistance Program, or SNAP, and social services, whether such individuals are employed by the state or political subdivision, related relatives and friends or of the non-custodial parent, current or past employers, electronic communications, and internet services. They all on the internet. They may not catch your ass on Facebook, Instagram, TikTok. They find you all on there. They gonna find you, especially you going by your real name on there. Anyway, and got your picture on there because she can identify your ass and she knows what you look like. So let's see. Utility companies. Utility companies, the U.S. Postal Service, financial institutions, unions, corrections institutions, fraternal organizations, police, parole, probation records, if appropriate, and the state agencies and departments as authorized by state laws, including those departments which maintain records of public assistance, wages, and employment, unemployment insurance, income taxation, driver's license, vehicle registration, and criminal records and other sources. So if your car is registered and you got an address using that, they're gonna use that to find you. All that social security number is attached to all of this shit here. All of this shit. So if they got that social, they're gonna use it to find it. That's why I never advise anybody to run from getting served. You're gonna get served some kind of damn way. They're gonna find your ass. So if they got that social, they can find you. So never run. Never run. You just stand firm and object to that shit and stand on it. They can't do it without your consent. But if you running and they find it, they got to do all that hustle and bustle to find out where you are, where your location, or they don't even have to find you. They can move forward because they got enough information about you to move forward. So they're gonna do it on your behalf using the power of attorney, of course. Okay, establish working relationships with all appropriate agencies in order to use locate resources effectively. Within no more than 75 calendar days of determining that location is necessary, access all appropriate location services and ensure that location information is sufficient to take the next appropriate action in a case. Refer appropriate 4D cases to the 4D program of any other state in accordance with the requirement of 303.7 of this part. The 4D program of such other state shall follow the procedures of program B1 through B3 of this section for such cases as necessary, except that the responding state is not required to access the federal PLS. Repeat. Let's see. I'm gonna read the whole. I'm gonna read the rest of it. Repeat location attempts in cases in which previous attempts to locate non-custodial parent or sources of income and or assets have failed, but adequate identifying and other information exists to meet requirements for submittal for location, either quarterly or immediately upon receipt of new information, which may aid in location, whichever occurs sooner. Quarterly attempts may be limited to automated services, but must include accessing state workforce files. Repeated attempts because of new information, which may aid in location, must meet the requirements of paragraph B3 of this section, and have in effect safeguards applicable to all confidential information handed by the 4D program that are designed to protect the privacy rights of the parties and that comply with the requirement of section 454.26 and 454 A, AD, and F of the Act, and 303.21 and 307.13. The state must establish guidelines defining diligent efforts to serve process. These guidelines must include periodic repeating service of process attempts in cases in which previous attempts to serve process have failed, but adequate identifying and other information exists to attempt service of process. So you see, they don't stop at nothing trying to find your ass. So you never want to be trying to hide from them. I never advise anybody to hide from these people. I was at the front. I saw the deputy sheriff at my front door. I saw him on the camera, so I just opened the damn door. I never run, and I don't advise y'all to run either. Okay, if the court or administrative authority dismisses a petition for support order without prejudice, the 4D agency must, at the time of dismissal, examine the reason for dismissal and determine when it would be appropriate to seek an order in the future, and seek a support order at that time, and let you know it can't be dismissed. So don't think for a minute you can't beat one. I beat one, and I'm on my second go around 7 years later, and I'm gonna be 2-0 in this motherfucker, because they ain't gonna get shit. They're gonna get it worse this time, because I'm not a beginner no more. I'm gonna have a lot more seasoned than I was before. It won't be no damn stressing like it was last time. Seek a support order based on voluntary acknowledgement. Voluntary acknowledgement in accordance with 302.7. And watch this. I bet it's talking about paternity. And I'm gonna show y'all how that. Let's see. What's this? 42. I think that is A57. A5. Hold up, see. Hold on a second. Let me make sure I got that right. Roman numeral 7. Support order. And this is Title 45, right? 302.7. says 5-7, right? A 5. Let's say A. And number 5. It's supposed to be 7. Hold on, let me go. Keep going down. Here we go. 4, 5, 6, 7. Procedures under which a voluntary acknowledgement must be recognized as a basis for seeking support order without requiring any further proceeding to establish paternity. Okay, so basically what you got to understand, procedure meaning a set of instructions in a record which describe in detail the step-by-step action to be taken by child support enforcement personnel in the performance of specific functions under the state 4D plan. The 4D agency may issue general instructions on one or more functions and delegate responsibilities for detailed procedures to the office, agency, or political subdivisions actually performing the function. So this is what you got to understand. This is what I got to use this as an opportunity to break this myth that people say once you sign the birth certificate, you on the birth certificate, or you do that paternity acknowledgement, you automatically on the hook for child support. No, that just means they ain't got to look for you. They ain't got to try to figure out who you are. They don't have to establish paternity. That's all they're saying right here. They don't have to paternity. They don't have to establish anything. Okay? Let's see, because I've already acknowledged that I'm the father. I cut my son's umbilical cord. I was there during the delivery. I was there the whole 9 months while she was pregnant. You know, I did all of that. I witnessed him come, being birthed into this world. And I did the paternity acknowledgement form right there at the hospital. And that's why I'm written. You can find my estate's name on his birth certificate. So keep that in mind. This is just that when they talking about trying to establish paternity, they don't have to establish it because they already got the paternity acknowledgement. They got the acknowledgement form already. So that's all they're saying right here. So they're trying to seek an order. And why they say seek an order? They ain't say I'm on the hook for an order. They say seek a support order based on voluntary acknowledgement. Okay? So it don't mean you automatically locked on there. You ain't locked in shit. You just landed. They mean they don't have to. You're not an alleged father no more. You're the one that they're going to acknowledge as the father because you signed a voluntary acknowledgement saying that you are the father. Okay. So understand that, man. Let me write that down. The acknowledgement. Okay. Make that a new thing right there. Okay. Establishment of paternity for all cases referred to 4D agency or applying for services under 302.3 to 33 of this chapter in which the paternity has not been established. 4D agency must have as appropriate provide an alleged father. See, they talking about alleged people who have not signed the acknowledgement, voluntary acknowledgement. Okay, I signed one of those. That's why I'm on the birth certificate. Okay, now provide an alleged father the opportunity to voluntarily acknowledge paternity in accordance with. I think that's what we just read right there. 30270. Yep, that's exactly what we just read. Say that's your opportunity to do that. Okay, attempt to establish paternity by legal process established under state law, like DNA testing and all that old stuff. If you do that, then if you do that through the courts, you automatically getting locked in because the companies that they use are directly linked to child support. So that is your agreement to be a part of it. So it's going to be implied that you agree with it. So if you're having doubts about a child, you might have thought she might have messed around with somebody else and the child wasn't yours and whatever it was, you got to take responsibility too, y'all. If y'all raw dogging somebody and y'all shooting up the damn club, stop that bullshit, man. How you doing that and be like, that ain't my baby? If you shot some sperm up in that woman, it's a chance it is. But not necessarily saying it is, but it is a chance it is yours. So you can't, without a shadow of a doubt, saying it's not yours. Stop doing that shit. Protect that shit. Put some goddamn rub on that meat. So, but back to my point right here. The thing is, you have to, you can, if you do it through the courts, if you don't know, you're having doubts whether or not the child is yours, they have paternity, they have a DNA testing outside of the court. You can do that privately. Why you think there's so many videos on the internet right now where dudes are coming to the baby mama because they secretly had the baby DNA tested to find out the child wasn't theirs. Baby mama never knew nothing about it. So you can do it on your own. It's through a private company. That way you'll have for sure, you'll know for sure this child is yours. And then you can, if you want to be on the birth certificate, you can do that. But don't think for a minute because you're on the birth certificate, you're on the hook for child support. It just means they don't have to look for an alleged father because they already have someone that's already acknowledged that they are the father. So that's all. That's what you need to understand. So that's who they know they can come after. So that don't mean that you locked in. You just have to know how to say no, and just file that shit. Make sure you stand on your answer. Now, 4D agencies need not attempt to establish paternity in any case involving incest or forcible rape, or in any case in which legal proceedings for adoption are pending. If in the opinion of 4D agency, it would not be in the best interest of the child to establish paternity. 4D agencies must identify and use through competitive procedures, procurement. Sorry about that. Procurement laboratories which perform at. See what I'm saying? Right here, the Title 4D agency must identify and use through competitive procurement laboratories which perform at reasonable cost legally and medically accepted genetic testing. That's what I'm saying. They are operating through Title 4D agency. If you go and give up some DNA testing, you're doing it through the Title 4D agency. They're using another company and they're both linked together doing business together. So if you do it through the courts, your ass gonna be locked in on child support. So if you might want to consider objecting that. Do that shit outside the court. You don't do that shit during the court if you're trying to take care of your baby privately and not be locked into a child support case. Because it says telling you right here, they're doing it through a reasonable cost. Reasonable cost, they probably gonna make you pay for it. But if it comes out negative, it won't cost you nothing. Okay, legally and medically accepted genetic tests which tend to identify the father or exclude the alleged father. The Title 4D agency must make available a list of such laboratories to appropriate courts and law enforcement officials. Okay, and to the public upon request. Something else. Upon request of any party in a contested paternity case, in accordance with Section 466A5B of the Act, and subject to the provisions of the program B of this section, the 4D agency shall require all parties to submit a genetic test unless in the case of an individual receiving aid under states Title 4A, 4E, or 14 plan. Let's see, 14 plan, or those recipients of the food stamp program, as defined under Section 3H of the Food Stamp Act of 1977, who are required to cooperate with the child support program. There has been determination of good. Now you're talking about these people who are receiving this. Most likely the baby dad ain't getting no food stamps. The baby mama she's required to do it. If she want to keep getting this here, she gotta unadd some damn DNA. So that's one of the reasons why they don't mind putting that pressure on the women to do that, because they in return they help them out with these programs. You know what I'm saying? They help them out with the kids, you know, with the supplying these programs and stuff like that to help them, help them with the kids or whatever. So if they can do that instead of getting them to work with you privately so y'all can raise the baby privately like y'all supposed to, they'd rather just here you qualify for this here program right here, but you got to do this here. You got to help us go against him. You got to do this. Cooperate with the child support program. Okay, there has been a determination of good cause for refusal to cooperate under Section 45429 of the Act. Okay, I don't even go to that right now, so I want to kind of stay focused on what we're doing right here. A contested paternity A contested paternity case is an action in which the issue of paternity may be raised under state law, and one party denies paternity, except as provided in paragraph E3 of this section, and 4D agency may charge an individual who is not the recipient of aid under state's Title 4A or 14. Well, that's 9. That's not 14. That's 9. Sorry about that. 19 plan. A reasonable fee for performing genetic tests. They'll try to charge it to the father since he ain't the one receiving no plan, no government assistance. So they always try to put the fees on the father most of the time. And even attorney's fees, they'll do that too. They tried it, and they'll try it anyway, but you have to object to all that. Any fees charged must be reasonable. Well, see, the thing is, you don't give them none of that shit. If you choose to give it to them, then that's on you. They're gonna put the order on you. Any fees charged must be reasonable, so as not to discourage those in need of paternity establishment services from seeking them, and may not exceed the actual cost of the genetic test. If paternity is established and genetic tests were ordered by the 4D agency, the 4D agency must pay the cost of such tests, subject to the recoupment. Subject to the recoupment if the agency elects from alleged father who denies paternity. If the party contests the results of the original test, the 4D agency shall obtain additional tests, but shall require the contestant to pay for the cost of any such additional testing in advance. 4D agency must use any amount collected under programs E1 and 3 of this section that exceeds the cost of performing genetic tests to reimburse any fee paid under paragraph 1 E1 of this chapter. The 4D agency must seek entry of the default order by the court or administrative authority in a paternity case by showing that process has been served on the defendant in accordance with the state law, that the defendant has failed to respond to service in accordance with the state procedures, and any additional showing required by state law in accordance with 30270A. I think is what we just read a minute ago. A5 Roman numeral 8. See right here? That's why I say when you get served, you're supposed to respond. Let's see. Let me see. Defendant in accordance. Let's see. Seeking the entry of default order by the court or administrative authority, most likely the judge, in a paternity case that's showing that the process has been served on the defendant in accordance with the law, and that the defendant has failed to respond to the service in accordance with the state procedures. That's how you get a default order against y'all. Right there, default order, because you failed to respond to the service in accordance with the state procedures. They're telling you right there, y'all. There's a lot of y'all get locked into these child support cases because y'all don't respond. You can't get served and don't want to respond, and then you just show up in there and bend over with your check stubs up in the air. You can't do that. You do that, then they're gonna bend you over. They're gonna go on and hit you with no grease. I'm just saying. Okay, I'm gonna read this apart. Let me see. I'm probably gonna do a part 2 on this here, because I'm not gonna cut this thing already 45 minutes long. I think that's what I'm gonna do. I'm gonna stop right there, y'all. I'm gonna do a part 2 on this, but y'all see right here, this is how y'all get defaulted when you don't respond. Okay, so this, I guess I'll name this video about voluntary acknowledgement, DNA, and default orders. That's probably what I'll name this. Hopefully y'all learn something off of that, and I'll go ahead and get off in part 2. Hopefully I'll get all 3 of these damn things recorded today. But hopefully, it's helping y'all to understand what they're doing, more about the process, more about the procedure, and understand that you have a choice when it comes to dealing with these child support programs. You don't get defaulted in it because you decide because they just do what they want to do. In some cases, they will. In all cases, they're going to try to do what they want to do, but it's up to you. According to the maximum law, he who fails to assert his rights have none. If you don't assert your rights, you don't have no rights. So you can't sit there and complain about it. You're too scared to assert your rights. You as a man, you need to assert your damn rights. Otherwise, they're going to railroad you as if you have none because you don't. Okay? Hopefully that helped y'all out. Stay tuned for part 2. Emerald signing out.